From getting a public defender who's meeting you for the first time the same morning as your trial, to using a single paperwork filing that reportedly makes 40,000 lawsuits disappear from a company's balance sheet in one afternoon, there's apparently no ceiling on how untouchable enough money and the right law firm can make you. The wild part? Technically, the same laws applied to everyone in this story the entire time. Level 1. The public defender line. Level 1 is the version of the legal system most people will actually meet. A public defender meeting his client for the first real conversation, sometimes minutes before a hearing. Roughly 90 to 95% of criminal cases in the U.S. reportedly end in a plea deal rather than a trial. Not necessarily because the deal is fair, but because a trial requires resources most defendants and their overworked counsel simply don't have the time or budget to mount. Bail itself reportedly compounds the problem before the case even gets that far. Someone who can't afford a few $1,000s in bail can reportedly sit in jail for months awaiting trial for a charge that, if convicted, might carry a shorter sentence than the wait itself, which means pleading guilty to something you didn't do can genuinely be the mathematically rational choice. The buyer here, if you can call him that, is a warehouse worker facing a charge he genuinely believes he could beat at trial, who takes the plea anyway, because the alternative is months in jail waiting for a court date he can't afford to gamble on. Here's what nobody tells you at this level. The system isn't rigged by breaking the rules. It's rigged by how expensive it is to actually use them. Level 2. The admission loophole. Level 2 belongs to a corporation, not a person, caught doing something a person would reportedly go to prison for. Corporate criminal settlements have reportedly, for decades, frequently allowed a company to pay a fine and accept a deferred prosecution agreement while explicitly admitting no wrongdoing at all. The buyer, functionally, is the company's shareholders, who absorb the fine as a line item, while the executives who signed off on the underlying conduct reportedly keep their jobs, their bonuses, and in some cases a promotion the following year. Nobody explains that part in the press release. The press release calls it accountability. It does not mention that the fine was reportedly budgeted for before the wrongdoing was even discovered internally. Deferred prosecution agreements reportedly emerged as a mainstream tool starting in the early 2000s, pitched originally as a way to hold a company accountable without destroying jobs and shareholder value by forcing a full criminal conviction. The most valuable legal document in the world isn't a not guilty verdict. It's a settlement that never required anyone to say guilty out loud. Level 3, the confidential room. Two lawyers sit across a table from someone who was genuinely harmed. A number gets written down, large enough that saying no to it would be its own kind of financial recklessness. And next to it sits a single-page agreement that says, in effect, none of this can ever be discussed publicly, by anyone, for any reason, ever again. This is Level 3, a confidential settlement with a non-disclosure clause attached, reportedly standard practice across nearly every major industry where a wealthy party is at risk of a public lawsuit. The payment isn't just compensation, it's reportedly priced, in part, specifically to purchase silence. The buyer is the company's general counsel, whose entire job in that room isn't winning. It's making sure whatever happened costs money instead of costing a headline. The signature on that page doesn't end the story. It just moves it permanently out of the only place where the public could have ever heard it. Level 4, the cost-benefit memo. This instinct has a famous decades-old paper trail. In the 1970s, an internal memo reportedly surfaced from a major automaker weighing the projected cost of a design defect lawsuit against the cost of an actual fix, and reportedly concluded in writing that paying out the lawsuits would be cheaper than the recall. The case became a business school staple specifically because someone wrote the calculation down instead of just doing the math quietly in their head. Level 4 is that same memo, done better, Legal and compliance departments at large companies now routinely reportedly run this exact projection. The buyer is a general counsel who's read that 70s case study in law school specifically as a cautionary tale about what happens when the math gets written down where a jury can find it. Modern compliance teams reportedly do the identical calculation today. They just route it through outside counsel and verbal briefings instead of a memo with a company letterhead on it. The lesson companies took from that case was never, don't run the calculation. It was, don't put the calculation in an email. Level 5. The insurance industry figured out risk transfer a century before corporate legal departments got this good at it. You don't eliminate the risk of a car crash. You pay a premium so someone else absorbs the financial consequence if it happens. Level 5 treats the legal system the exact same way. A company or individual with enough money doesn't try to avoid ever being sued. They budget for it, retaining the most expensive litigators available, not necessarily to win outright, but reportedly to make the cost and duration of fighting them so punishing that most plaintiffs and their lawyers calculate it's not worth pursuing at all. The buyer is a mid-sized firm's legal team that reportedly settles smaller claims quickly and quietly, while routing anything involving a well-funded opponent through years of procedural motions. Plaintiffs' attorneys reportedly factor this exact dynamic into which cases they'll even take on contingency, meaning a legitimate claim against a company with a famously aggressive legal department can reportedly get turned down by multiple law firms, not because the case is weak, but because the projected years and cost of fighting it make it financially unworkable for anyone without the same resources on their own side of the table. Insurance never promised the crash wouldn't happen. It just made sure whoever caused it wouldn't personally feel the full weight of it. Level 5 applies the identical logic to a courtroom instead of a highway. Level 6. The two-step shield. At this level, the company itself starts disappearing on paper before a single lawsuit is even filed. A legal maneuver sometimes called the Texas two-step, reportedly used by several major corporations facing mass tort litigation, works by splitting a company into two entities right before a wave of lawsuits arrives. One entity reportedly absorbs the liability and all the lawsuits attached to it. The other keeps the valuable assets, the brand, the operating business, completely separated from the legal claims aimed at the first one. The liability-holding entity then reportedly files for bankruptcy almost immediately, which can pause every single lawsuit against it at once, sometimes tens of thousands of individual claims, frozen in a single afternoon by one filing. The buyer, in this scenario, isn't a person at all. It's a boardroom that reportedly approved a restructuring plan drafted entirely around a piece of Texas corporate law that allows exactly this kind of split, a maneuver critics have reportedly argued was never intended to be used this way. And courts have been reportedly divided for years on whether to allow it to stand. Level 7. The priced-in consequence. The public defender's client at Level 1 had no ability to calculate risk in advance. He simply absorbed whatever the system handed him. Every level above him, all the way up, was built entirely around the opposite privilege, the ability to calculate the cost of consequences before the conduct even happens, and decide with a straight face and a spreadsheet that it's still worth doing. That's the actual final shape of Untouchable. It was never about being above the law in some dramatic, cinematic sense. It's about having enough resources to treat the law as a predictable expense instead of an unpredictable threat. Insurers reportedly even sell specific policies designed to cover exactly this category of cost, executive and corporate liability coverage, that pays out settlements and legal fees the same way a homeowner's policy pays out for storm damage, meaning the consequence of getting caught isn't just calculated in advance. In many cases, it's reportedly already insured against before anyone involved has done anything wrong at all. At every level below the top, you were hoping to avoid getting caught. At level 7, getting caught was already in the budget before anyone did anything wrong. So next time someone tells you the rich don't face consequences, they're not quite right. They face consequences constantly. They just face them the way the rest of us face a subscription renewal, expected, budgeted, and mildly annoying at most. The warehouse worker from level 1 and the boardroom from level 6 broke. Functionally, the same category of rule. Only one of them got a plea deal negotiated by someone he met that morning. The other got a restructuring plan negotiated by a law firm that had been on retainer for a decade in case this exact day ever came. Justice, it turns out, isn't blind. It's just extremely good at reading a balance sheet before it decides how hard to look. The videos are the introduction. The books go deeper, go beyond the videos. Read my books.